Hello and welcome to the Law Lab YouTube channel. Here we dissect and unpack everything legal. My name is Aaron Asiedu Entry. Today we are looking at law of contract, specifically unilateral mistake. And more specifically, we are looking at unilateral mistake as to the identity of the contracting party. Before I proceed, I would implore you to like, comment, share, tell a friend to tell another friend that the Law Lab is on to help dissect and unpack everything legal. We've started with the vitiating factors, dealt with mistake, and dealt with the first kind of mistake in our previous video, which is mutual mistake. Today we are looking at unilateral mistake. And if you heard me at the beginning, I mentioned that more specifically, unilateral mistake as to the identity of the contracting party. Why do I say so? When we say unilateral mistake, it means that one person is making the mistake. And mostly when one person is making the mistake, he makes the mistake as to the identity of the other party he or she is contracting with. So certainly you intend to, let's say A intends to contract with B. However, C comes to deceive A that C is B. Even though C is not B, then he tends to contract with A. So C becomes a rogue, purchase the item with maybe a dummy check or a bad check. Let me put it that way. A fake check. And that check will be dishonored. Meanwhile, the rogue, that is C, has picked the said item or goods from A and has gone to sell to, let's say, D. And D becomes a bona fide purchaser for value. So this is the type of mistake we are going to look at today. And why we say it is a unilateral mistake as to the identity of a contracting party is what I'm repeating again. One party intends to contract, so party A intends to contract with B, but ends up contracting with C because C has represented him or herself as B to A. And so he picks the item and now goes to contract or sell the item to, let's say, party D, and party D becomes a bona fide purchaser. Let's look at the position of the law under unilateral contract, unilateral mistake as to the identity of the contracting party. First thing, for you to be able to plead under unilateral mistake as to the identity of the contracting party, you must first prove to the court that the said contract or promise was directed to you. The said contract was directed to you. I refer you to the case of Bolton versus Jones. In this case, Jones had a contract arrangement with Brocklehurst. Jones, the defendant, had a contract arrangement with Brocklehurst. And what happened with the said contract arrangement is that the defendant, i.e. Jones, had the right to set off any contract he had or any transaction he had with Brocklehurst. Unfortunately for Bolton, he took over the business from Brocklehurst, but did not inform Jones that he has taken over the business. So what happened was that he transacted again with Jones, and Jones, thinking that he's contracting or he's still in business with Brocklehurst, set off the said amount against the goods that was supplied. He sought for his money from Jones, and Jones said, well, I'm in contract with Brocklehurst, so I don't know whether when you even took over the business, and you should have informed me. And so the court said that Bolton cannot succeed by pleading mistake as to the identity of the contracting party because he must actually have informed the said Jones that I've taken over the contract from Brocklehurst, so that Jones would have known that now I'm dealing with a new person. And so to plead mistake as to identity or unilateral mistake as to the identity of the contracting party, that will not lie. The next thing we must look at is that I mentioned to you that with this type of mistake, it mostly deals with a rogue fraudulently representing himself as a certain party of which he is not. Remember, in our criminal law discussions, I mentioned to you that when we talk of fraud, when we say someone has defrauded another person, it means that the person actually knows the truth and he's telling a lie. He knows that what he's saying is a lie, and he intends to peddle that lie or sell that lie to gain a certain benefit as to the detriment of the other party who is at the receiving end of being told the said lie. That is basically it. So when you come to unilateral mistake as to the identity of the contracting party, what it clearly means is that one party is presenting him or herself as another party of which he is not, so that he will be able to purchase an item from the plaintiff, because certainly it is the plaintiff who would now go and plead mistake in court. And so he tells the plaintiff that I am A, meanwhile he or she is not A. Then it ends up that he has actually purchased the goods and sold it to another party. The most unfortunate thing is that when you sell it to another party, the party becomes a bona fide purchaser for value. But you see, the rogue who sold the item to the third party does not have title. And in law, we have a principle we call nemo dat quod non habet. You cannot give or pass a title, or you cannot pass a good title or a title that you do not have. And this principle stems out from the Bible verse in the Holy Book of Acts. And if I may refer and tell you, Acts chapter 3 verse 6, he says that then Peter said, silver and gold I have none, but such as I have I give I thee. In the name of Jesus Christ of Nazareth, rise up and walk. All that it means is that Peter does not have silver and gold, so he cannot give the said person, the said cripple, silver and gold. So you cannot give a title that you do not have. Nemo dat quod non habet rule. As simple as that. So when a rogue purchased or fraudulently purchase an item from the rightful owner and sells to the third party, the rogue does not have title and cannot pass the title. And so immediately that we establish that the rogue has sold the item, or we've established the said mistake, that unilateral mistake, the contract becomes void. It means it is unenforceable. We even think that it did not even exist in the first place. But if the said contract or the said mistake is not established, it makes the title in the goods voidable. Voidable in the sense that when the rightful owner takes immediate steps to establish the mistake, then he can void the contract or set it aside and gain back his goods or title of the goods. As simple as that. If he does not, it means that the rogue has now passed a good title. So when you sleep on your rights and time lapses, it means that the rogue will have a good title and pass that title to the third party. But when the said mistake is heavily or immediately established, then you get to know that you can go back or it will void the said contract between the rogue and the third party, and you can gain your goods back. One thing I want us to know is that when it comes to mistake, there are three elements you must prove before the court. And I refer and mention them to you. In establishing that mistake as to the identity of a contracting party has happened, you must go by these three guidelines. One, you must tell the court that you intended to deal with some person other than the rogue, and the rogue knew that you did not intend to deal with him or her, but you intended to deal with some other person. And two, that at the time of entering into the contract, you regarded the identity of the person you were contracting with as crucial. And the third point is that you took reasonable steps to verify the identity of the person. So I said three elements and I'm repeating them again. One, you must prove to the court that you intended to deal with a different person other than the rogue. And the rogue knew that you intended to deal with a different person, not him or her. Two, at the time you were contracting, at the time you were contracting or entering into the contract, you considered the identity of the rogue as a matter of crucial importance. And the third one is that you took reasonable steps. You took reasonable steps to confirm or verify the identity of the rogue. So if you're able to prove to the court that I did all these three things and still you ended up contracting with the rogue, the court can now safely agree with you that indeed mistake, as a unilateral mistake as to the identity of the contracting party would lie. As simple as that. Now, I would want us to consider these two cases. First, we will be considering the case of Cundy. It depends on the school you attended. Cundy or Cundy versus Lindsay. And also, we'll be looking at the case of Keynes Norton Metal Company Limited versus Edrich, Merritt and Co. Keynes Norton Metal Company Limited, Edrich, Merritt and Co. Limited. Now, I pick the first case, Cundy or Cundy versus Lindsay. In Cundy versus Lindsay, a rogue called Blackhand wrote a letter to Lindsay representing himself to be Blenkiron. And Blenkiron has been widely known as of that time to Lindsay as a reputable firm. Now, what happened was that Lindsay, knowing that, Blenkiron is a reputable firm, got to know that, wow, then this letter is coming from a reputable firm, we are going to engage them. And Blackhand, who is the rogue and portraying as Blenkiron, ordered for large sum of handkerchiefs. So Lindsay quickly delivered to the address of Blenkiron, thinking it is that of Blenkiron, but unfortunately, it was the rogue that has given the rogue Blackhand, who has given a fake address to suit that of Blenkiron. Now, the rogue went ahead to sell the handkerchiefs to Cundy. Lindsay has found the handkerchiefs with Cundy and has brought an action against Cundy to get the handkerchief in the name or in the quest of surviving under the action of unilateral mistake as to the identity of the contracting party. At this material point in time, as a student, you must be using the three tests to run through to see whether the court will rule in favor of Lindsay as against Cundy. I told you that the three tests are very simple, the three elements. One, that the plaintiff intended to contract with a different person and not the rogue, and the rogue knew that the person did not intend to contract with me, but a different person. Two, at the time of concluding the contract, the plaintiff took, or as a matter of crucial importance, considered the identity of the contracting party. And the third one is that the plaintiff took reasonable steps to verify the identity. If you've been able to run through, I believe that you formed your opinion already. But hey, the court said that, well, mistake as to the identity of a contracting party, the identity of the contracting party should lie. I mean, unilateral mistake as to the identity of the contracting party should lie. However, let's contrast this case with Keynes Norton Metal versus Edrich, Merritt and Co. Limited. With regards to Keynes Norton Metal Company Limited versus Edrich, Merritt and Co. Limited, here the rogue Wallace actually wrote a letter on the letterhead of Hallam and Co. That company never existed. He created it with a fictional address to order large sum of goods. He received the goods, sold it to Edrich, Merritt and Company Limited. Now, Keynes Norton Metal has been able to find out that the goods are with Edrich, Merritt and Co. So Edrich Company now becomes a bona fide purchaser for value, because for value or without notice. Bona fide purchaser for value without notice. They did not know that the person is a rogue, and as such, as to whether or not they have acquired a good title, you should now be able to run the three tests in this process to know whether or not the court will rule that indeed there is a unilateral mistake as to the identity of the contracting party. Now, the point over here is that the court said no, that will not lie, even considering the three tests. And don't forget, I'm repeating the three tests again. One, there should be you should prove to the court that you intended to contract with another party or a different party other than the rogue, and the rogue knew that you intended to contract with another party other than he or she, the rogue. Now, or the second point is that you consider the identity of the other contracting party as a matter of crucial importance. And the third one is that you took reasonable steps to verify. The court in Kings Norton Metal Company Limited versus Edrich Merit and Co. Limited, the court is saying that no, this is not a unilateral mistake as to the identity of a contracting party, because the company Hallam and Co. itself does not exist, and you did not even take any reasonable steps to verify whether they existed or not. And so the court did not rule for Kings Norton Metal. Ladies and gentlemen, this will lead us to our next video, where we will be talking about contract inter presente. Contract inter presente. And what happens in contract inter presente is that there is a presumption in law. It is a presumption under common contract law, which says that when I contract with you face to face, you cannot come back to tell me that you did not intend to contract with me. We'll delve much into that in our next video. Thank you very much for sticking through.